of the questions that I get frequently from potential clients is, what is a contingent fee agreement? Well, in the state of Washington, in a personal injury setting, a contingent fee agreement must be in writing. And contingent simply means that the fee is contingent on recovery. In the event that there was no recovery, then there would be no fee. One of the most important things to look for when you're reviewing a contingent fee agreement with a potential attorney is, does the agreement specifically state that the attorney that you're hiring will be the attorney that represents you throughout the entire case? Some contingent fee agreements provide that the attorney can delegate to an associate or another attorney in the firm. You want to make sure that the attorney that you're hiring will continue to represent you throughout the matter. The next question that I often get is, what is the difference between a fee and a cost? Let me give you an example. When an attorney is dictating a letter, or is on a telephone call, or is meeting with a client or an insurance adjuster, taking a deposition, all of the activities an attorney does to prosecute a claim is his or her time. The time is what generates the fee. In an hourly rate case, like a divorce or other types of real estate transactions, etc., every hour or every minute is billable by the attorney. But on a contingent fee agreement, the contingent fee agreement specifically states that the fee will be a percentage of the recovery at the end of the claim. That's what a fee is. A cost, on the other hand, is when the attorney actually takes some money out of his pocket and purchases something to prosecute the claim. A good example in a personal injury case would be a police report. When a copy of the police report is ordered from the Washington State Patrol, there's a charge associated with that. Medical records, medical billings, a filing fee with the court. These are funds that the attorney advances on behalf of the client and is repaid at the end. Those are called advance costs. So you can see the distinction between a fee and a cost. Make sure that the fee agreement that you're reviewing makes a complete distinction between a fee and a cost. Next, what will the fee be? It says a contingent fee. What is the contingent fee? Well, in most cases today in Washington, lawyers use what's called a sliding scale contingent fee. We're going to look at an example here. Under paragraph number 3, it states that if the case settles prior to litigation, the contingent fee will be 1/3 of the gross settlement. Going to page 2 in paragraph 3, section B, you will see that if the attorney files a lawsuit with the client's permission, and that's an important distinction, make sure that the contingent fee agreement provides that the attorney must get permission from the client before filing a lawsuit. In this instance, the contingent fee agreement goes to 35% once litigation or a lawsuit is initiated. Section C states that if the case goes to arbitration, the contingent fee goes up to 37.5%. And finally, if the case went all the way to trial, you'll see in section D that the contingent fee agreement goes to 40%. Now, of course, very few cases end up going to trial, so most cases will settle in the 1/3 to 35% range. Below that, you'll see that there is actually a formula that shows how the contingent fee is computed based upon the gross recovery. One line that clients often ask questions about is the subrogated interest. What is a subrogated interest? Well, an easy way to think of that is some other entity that has an interest in the recovery. Most usually, this would be your own personal injury protection insurance that's been paying your medical bills throughout the case. Although it could be healthcare insurance or other providers that have paid something towards your recovery or your economic loss. We can cover that in more detail in another section called subrogated interest that we will do at a later date. One of the most important sections that I always advise clients to look for when they are out interviewing potential attorneys to represent them on a personal injury claim is what happens in the event that the case is to settle And I would direct your attention to paragraph number 5 in this contingent fee agreement. And let me read this to you. It says, "This is your case. Prior or before any settlement, we will first obtain your approval." Now that doesn't sound particularly complex or revolutionary, but if that paragraph is not in your contingent fee agreement, it means that the attorney retains the right to determine when the case could settle, and you don't have anything to say about that. I always advise clients that they should ask for inclusion of a paragraph that they approve any settlement if it is not already in the contingent fee agreement. It's preferable if it's already in the contingent agreement, because that means that both the attorney and the client are on the same page, and that the attorney must obtain client permission before settling the case. You will also want to look to see if there's an agreement that you can terminate if you need to, and what the percentage of the fee would be if a termination has to occur. Now, in most contingent fee agreements, you're going to see a power of attorney. This is because the attorney needs to sign documents on your behalf in order to be able to competently represent you in a personal injury case. You might also see a paragraph indicating that if you declare bankruptcy during the pendency of the case, that you will inform the attorney. Why would that be? Well, the personal injury case becomes an asset of the bankrupt estate. And therefore, if the attorney continues to work on the case without knowing that you've declared bankruptcy, he will then get a letter from the bankruptcy trustee asking him why he's proceeding to represent a case where he's not been appointed special counsel by the trustee. So that's what that paragraph's about. And then lastly, you will generally see a line for you to sign as the client, a notary public to verify, and then an acceptance by the attorney. And only after the agreement is signed by the attorney does this become a binding agreement. I hope that answers the question of what a contingent fee case is and what is a contingent fee agreement. My name is Steve Lingenbrink. I'm a personal injury attorney. Our phone number is 425-284-6000. And if you'd like further information, you can definitely go to our website at lingenbrink.com. Also, you might be interested in looking at our YouTube channel at Lingenbrink Law. Thank you.